So we have been going through the Constitution. This is our ongoing journey that, we still got a ways to go through here yet, but this is civics portion of the show here. So where we ended up last time was we finished Chapter 2, or Article 2. So now we're on Article 3, which is the judicial branch. So this is the shortest article of the three branches of government. Article 1 was the longest with the legislative branch or Congress, and then Article 2, which is the executive branch, which is the presidency, and then Article 3 is the judicial branch. So there's just three sections in Article 3. And the founders put this, made this one of the branches of government because under the Articles of Confederation, we didn't have a national judiciary. So this was a problem. So state courts, each state had their own court system, and of course when there were lawsuits between states or people in different states, it wasn't unusual that the state courts ruled in favor of that particular state. So the founders set up a national court system. Now you could, I'm going to make an argument in a future show that I think the courts have a little bit too much power than what the founders actually thought they were going to have. So on the other hand, though, I'll also make the argument, well, maybe this is what the founders intended. Because most of those guys were part of the elites, right? They're rich people. And they feared that the, angry masses of people would overtake them because there were more of them than there were of the elites. So they set up the court system, the federal court system, to protect their property and economic, well-being of the elites. And, that's certainly what the federal court has been doing, especially the Supreme Court here lately. So anyway, that's a topic for a future show. So let's get into Article 3. So Section 1 is the part that actually sets up the Supreme Court. But it doesn't say anything about how many cases they got to hear. It doesn't say how many are on the Supreme Court. It just says there's going to be a Supreme Court. Right? So, and then Section 1 also says that Congress sets up the rest of the federal court system. So we went through this earlier in Article 1 where it specifically says one of the powers of Congress is to set up the national court system. So it says it here in Article 3 as well. So the Supreme Court is established by the Constitution, and then Congress sets up the rest of it, which they did starting with the Judiciary Act of 1789. So the first Congress set up the first federal court system, and then it's gone from there over time. So one of the key things, though, in Section 1 is that federal judges, so this is all of them, including the Supreme Court justices, but all federal judges, hold their office during good behavior, it says, whatever that means. It's not defined in the Constitution. And that you can't reduce their pay. So this is one of the big differences between the federal court system and the state court system are that federal judges are not elected, other than they have to be approved by a majority of the Senate before they can become federal judges. So if the president nominates somebody, if a majority of the Senate votes to approve them, then they become a federal judge and they serve for life, or until they quit, or in some cases until they're impeached. But there's no elections. So this is one of the criticisms that some people make of the federal court system is, well, you don't have any elections. But again, this was the justification for this as well, that they want to be independent of politics by what their decisions are. So that's certainly a debatable thing here. But the part about reducing their pay, this is something that England was doing. Remember, we borrowed a lot of our court system from England. So England at that time was ruled by a king, and if the king didn't like what some of the judges' rulings were, well, then the king or parliament would reduce the judges' pay, or in some cases even take away all their pay, so that they end up quitting as judges, and then they can replace them with a judge that's more friendly to the king. So that's why that part's in there, so you can't reduce their pay. So one of the things that people are arguing about the Supreme Court and maybe limiting them a little bit as well. Let's try and impeach them for not having good behavior. Now again, you're going to run into there's no definition of that and there's no process for that. Really, I don't know that it's been tried, but some people are arguing the corruption that arguably Thomas and Alito are doing isn't good behavior. So let's try and kick them out under there. So, that's something that might be pursued, but I don't know that it's going to get anywhere, especially with, the way the Senate is structured at the present time. All the more reason to, keep the Democrats in charge of the Senate. Because they're the ones that are going to, if Harris wins, if the Democrats control the Senate, then they get to choose their judges, which is a good thing. So, Section 2, Clause 1 is about the jurisdiction of the federal courts. So jurisdiction in a legal setting means the power to hear a case. So the federal courts cannot hear every case. State courts cannot hear every case because they have different jurisdictions. So this part of the Constitution lays out the jurisdictions of the federal court. Now, I'm not going to go through all of them because it's a little complicated and there's kind of a long list of them here, but I'll go through the main ones. So these include cases involving the federal Constitution, federal laws, treaties, federal administrative agencies' rules and regulations, cases where the federal government is a party, lawsuits between states, and lawsuits between people of different states. So these are the main cases that the federal court has jurisdiction over. So that's where you would start your cases. Now, there's one caveat for the lawsuits between different people from different states. If your case is for monetary damages for injuries that were done to you, let's say I was driving in Texas, somebody in Texas hit me, and I incurred $100,000 worth of damages, I could sue in federal court. But if my losses were under $75,000, then I can't sue in federal court in a case like that. Then I got to go to state court because Congress passed a law earlier that set that out as far as civil cases for monetary damages. In order to be in federal court, you have to have over $75,000 or at least allege that in your complaint. Otherwise, you got to go to state court. So if you can't meet the federal court jurisdiction, then you end up going to state courts. Clause 2 is about cases involving the Supreme Court specifically. So they have original jurisdiction, meaning that's where you hear cases first, originally, right? So these are very limited, but they include ambassadors, ministers, and consuls. In other words, these are people from other countries. Cases in which a state is a party. And that's it. So, not too many cases the Supreme Court has original jurisdiction over. Now, most of the Supreme Court cases are where they have appellate jurisdiction, meaning they hear appeals. So, what happens there is that at the trial court level and federal court, a judge makes a decision and it gets appealed to the Court of Appeals, and usually 3 justices hear your case there. And if you still lose there, you can appeal to the Supreme Court, which may or may not take your case. They don't have to. But if 4 out of the 9 agree to hear your case, then they will hear your appeal. Most of the time, people that petition for review don't get it. But the Supreme Court does. That's what you got to do to get your case heard through an appeal. So, Minnesota, by the way, is in the 8th Judicial Circuit Court of Appeals. There's 13 of them. We're in the 8th one. And usually you have 3 judges, but depending on your local rules, there can be more than 3. But usually it's 3. Clause 3 says that all criminal trials, except impeachment trials, because remember, impeachment trials happen in the Senate. And by the way, they're not criminal trials, right? They're political incidents. So if you have a criminal trial, again, this refers to federal criminal trials. So federal courts have jurisdiction. You can have a trial by jury, it says in there. And the trial is in the state where the crime occurs. So here again, it kind of lays out that you have a right to a jury trial, and it has to be in the state where the crime occurs. Now, there's a little caveat here, is that if you are a defendant in a criminal case, in other words, you're the person charged, you're the one that's on trial, you can actually ask for a judge to hear your case instead of a jury. You don't have to go with a jury. So that's a decision that the defendant gets to make. The prosecutor does not. So the defendant has a right to whether they have a jury trial or a judge trial. But Clause 3 lays out that if you are charged by the feds with a criminal charges, you have a right to a jury trial, unless you just want a judge. So again, no, this involves federal crimes. It does not involve state crimes. Most crimes are resolved in state courts, but there are some federal crimes that occur on federal land or that cross state lines. So then you're in federal court. Section 3 then is Clause 1 is about treason. So it defines treason as levying war against the United States or aiding or comforting an enemy that has levied war against the United States. But in order to convict somebody, you need 2 witnesses to the same actions involving the treason, or the defendant confesses in open court. So you need one of those 2 things in order to convict somebody of treason. And then Clause 2 says that the punishment of treason gets to be set by Congress. So right now, Congress has set the minimum sentence for treason as 5 years in prison and or a $10,000 fine, with the maximum sentence being death. So you can get convicted of, if you're convicted of treason, you can spend up to at least a minimum is 5 years in prison and the maximum is death. So, or it can be anywhere in between. So, it's up to the judges there. So, as I said, Article 3 is short, so we're done with Article 3 in the judicial branch. So next week we'll start on Article 4.